Welcome back to our investigation into the structural errors of modern governance. Today, we dismantle Presumption 4, the belief that statutes are automatically law. Look at almost any modern political debate, and you will find a shared, unspoken premise. The assumption is that the moment a legislative body writes a bill, subjects it to a vote, and passes it, that resulting document instantly possesses binding lawful authority over you. The American founding legal tradition rejected that proposition entirely. To the framers, legislative will and lawful authority were not the same thing. They recognized a severe distinction between the two. An enactment is simply a procedure. It is text on a page adopted by a committee. A true law, however, is a rule of right. It applies equally. It avoids creating special privileges, and its primary function is to protect existing liberties, not infringe upon them. When you collapse this distinction, treating the mere action of the legislature as the absolute source of legality, you remove the boundaries of constitutional government. The legislature ceases to be a delegated, limited body and becomes the unquestionable source of power. To understand why this is a structural error, we have to look at the traditional hierarchy of law. At the very top sits what William Blackstone defined as the law of nature. He wrote that this natural law is superior in obligation to any other, and crucially, that no human laws are of any validity if contrary to this. Looking at this structural flowchart, immediately beneath that universal standard rests the Constitution. This operates as a written trust instrument, a specific document where the people delegate very limited, defined authority to a government. Only underneath those two superior authorities do we finally find the legislature and its statutes. Notice how the authority moves. It flows strictly downward from the natural rights of the people, through the constitutional trust, and finally to the legislative agents. Because a statute sits at the bottom of this chain, it possesses zero independent authority of its own. Its legitimacy relies entirely on obeying the levels above it. Alexander Hamilton laid out the exact parameters for how this delegated power operates in Federalist No. 78. He established a baseline rule for agents acting on behalf of a principal. Hamilton wrote, "Every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void." He warned that believing otherwise creates a logical absurdity. It would require accepting that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves. A legislature is nothing more than a creature created by the Constitution. It is logically impossible for a creation to outrank the creator. When a statute conflicts with the Constitution, it is not a battle between equals. It is an agent attempting to overrule the entity that gave it life. This boundary was later articulated by constitutional scholar Thomas Cooley, who clarified the limits of legislative will. He detailed precisely when an enactment crosses the threshold into legality. Cooley stated, "For the will of the people, as declared in the Constitution, is the final law, and the will of the legislature is law only when it is in harmony with, or at least is not opposed to, that controlling instrument. The Constitution acts as a rigid chain on the legislative body itself, binding lawmakers as strictly as it binds any private citizen. The legislature is not exempt from the rules. It is governed by them. Any enactment produced by that body that conflicts with its superior authority necessarily lacks the force of law." We have to draw a hard line here between a statute that is simply flawed and an enactment that is completely void. A bad law might be highly unpopular. It could be economically unwise, poorly drafted, or deeply unjust. But if it stays within the boundaries of delegated power, it still technically possesses lawful authority. An unconstitutional enactment is entirely different. It suffers from a terminal defect right at its source. By attempting to wield power that was never delegated to it, it fails to meet the basic requirements of legal existence. Because it lacked authority the exact moment the final vote was tallied, it cannot gain authority later. Publishing it in a statute book, enforcing it with police power, or letting decades pass does not cure the defect. What lacked authority at its creation remains without authority forever. This strict framework is not an abstract theory. It has been repeatedly affirmed by the highest levels of the American legal tradition. In Marbury v. Madison, Chief Justice Marshall declared that a law repugnant to the Constitution is void. In Van Horn's Lessee v. Dorrance, the court similarly ruled that every act of the legislature repugnant to the Constitution is absolutely void. The clearest articulation came in Norton v. Shelby County, which stated, "An unconstitutional act is not a law. It confers no rights, it imposes no duties, it affords no protection, it creates no office. It is, in legal contemplation, as inoperative as though it had never been passed." This brings us to the historic legal maxim that summarizes this entire condition: void ab initio, void from the beginning. Any act contrary to the rule of right is inherently an injury. It never possessed an ounce of lawful force from the very start. The presumption that statutes are automatically law reverses the entire constitutional hierarchy. It places legislative will above constitutional delegation, and it elevates the government above the law that created it. A legislative command designed to violate pre-existing life, liberty, or property remains an act of usurpation. It does not matter how many votes it received, and it does not matter which book it is printed in. Legislative desire alone can never transform an unauthorized enactment into a lawful one. The legislature itself possesses only limited, delegated authority. This series explores the false presumptions of government. Today, we close the book on Presumption 4, the false presumption that statutes are law. True law is a rule of right, and unless government enactments align with that superior standard, they are not law at all.